Today I ended up having lunch with a young woman who works at our office who's thinking about going to law school. And she asked me what my advice was. And I said, make sure you do something that you're really passionate about. And I've been lucky in my career to be able to do what I really love to do. So I have a bachelor's degree in gerontology, which is the study of how our society responds to the aging of our society, how we provide benefits, how we get ready for it, what we do. It's always been something I've really, really enjoyed. And trusts are the same. So some people on here might think, oh, she's a little crazy that she likes trust law, but I actually really do. So I'm enjoying. I was looking forward to spending this time. And as the title talks about, it's anything and everything you'd want to know about trust. Of course, the PowerPoint that we created really thinks about the most used trusts. So as Kyle said, if you have a different situation or you have a question, don't hesitate to put that into the chat. Unmute yourself. And I can't see the chat while I have my PowerPoint up, but Kyle will alert me to that and we'll stop and make sure that you get any questions that you have answered. So when we think about this, what we're going to discover is really how the assets are managed once they're placed within the side of the trust. So and this is really the questions that I get most often from our clients, like, if I put my house in this trust, what does that really mean? We're going to talk about common scenarios for using a trust, like why would you want to use it? We don't just want to use a trust, we want to have some sort of a benefit to having used that. We want to assign different roles and execute decisions. We're going to talk about who really has control, who can unlock the trust. Sometimes I think of a trust as like a closet, like who has the key to open the door. And then we're going to spend a good amount of time talking about using a trust to help fund long-term care costs. Because for many of us, the largest thing that we have to worry about as we age throughout the second half of life is what happens if we get sick. How do we protect assets for our spouse? Make sure that we have the assets to pay for levels of care that aren't paid for, and really accessing good care. And sometimes we use a trust for that. For some of you, you shouldn't use a trust. You should purchase long-term care insurance, and we can kind of talk about that. So this seminar, you're in the right place. If you've ever really considered unsure whether the trust that you have or that you think that you might want to meet your goals is revocable or irrevocable, we're going to talk about that. Scared of doing anything with a trust because you want to be able to make your own decisions. And we'll talk about how a lot of even irrevocable trusts, you still can make your own decisions. And really, the idea of planning ahead like this is for people who really want to make sure that you and your family are in control. That if a crisis happens, you're not subject to whatever the default in Pennsylvania law is. And I know some of you on here might be considering doing this, and some of you might be in a situation where you've already done this and you question, why did I do it? And does it still meet my purpose? And I really applaud you for being on here because really planning ahead is something that you have to do for yourself. So as Kyle indicated, we have offices across 6 locations now across North Central Pennsylvania. But our firm, we use trust for a lot of different reasons. Maybe it's special needs planning. Maybe we're dealing with somebody who has a diagnosis of dementia and we're trying to access benefits. But I even use trust sometimes in business succession planning, veterans benefits, elder care navigation. So our firm really focuses on things that you would need in the second half of life. How do you make sure you protect yourself if you die or you get sick, and successfully transfer to the next generation? As Kyle indicated, I am the original author of the Pennsylvania Trust Guide. It is now updated by myself, Samantha Wolf, and Jenna Franks. Jen and I are partners here at the law firm, and Sam is somebody who used to work here and still does a great job. But we also have books about living with dementia, protecting our families, really understanding what we need to know. So if you're interested in any of these, just let Kyle know, and it's certainly something we can get to you. I am a fellow member of the American College of Trust and Estate Council. There are really very few of us in Pennsylvania that are members of that. And honestly, besides Amos Goodall, I think I'm one of the only people in the north central part of the state. Most of those attorneys come out of Philadelphia and Pittsburgh. I did recently go back and get an LLM, which is like a master's degree after your law degree in elder law and estate planning. As you get older, you have to think about, do I still know this stuff? How can I like really brush up? And so, important to know who's talking to you and what perspective we come from. So let's talk about what exactly is a trust. It's really, I say to clients all the time, saying that you have a trust is really no more descriptive than saying you drive a car. It doesn't really tell us much. Do you drive a Jeep? Do you drive a Cadillac? What is it? And I think the same is true for the word trust. You can say that you have a trust, but that doesn't tell us very much. Doesn't tell us what type of trust it is. Really, it's just a legal document with a written set of rules. A trust will typically always name who the beneficiary are. That's who ultimately gets it. Who the trustee is. A trustee is the person that is really the decision maker, the person that invests property, decides to sell the real estate. A trust protector is somebody who can take action to protect trust and the trust assets. And we use a trust protector often in a situation where we're trying to protect assets from the cost of long-term care. Maybe we have a husband and wife. One of them has dementia, and we want to make sure that the other one doesn't become financially compromised. That's a great use of a trust for long-term care, and typically we would always have a trust protector. Now, in those situations, we're going to have very explicit what powers does a trustee have, what powers does a trust protector have. So even though today I'm going to talk about these kind of things generally, remember, a trust is a written set of rules. So to see what happens in that exact trust, we sometimes have to go back to that. We're also going to talk about taxation, because that's the biggest thing I get. I get people saying, well, I can't do a trust because it's going to pay higher income tax. That is not necessarily true. We're going to talk about different types of trust. And the trust that we use the most often is a type of trust that it doesn't matter. The IRS acts like it doesn't even exist. And then the spendthrift clause is typically in almost every trust. And that's a clause that says, whatever I do, can't be caused against the trust. So let's say, for instance, I have a child who I have concerns about their financial decision making. Maybe they have some substance abuse problem. If I put their inheritance in a spendthrift trust, then what happens if they rack up a whole bunch of debt? That debt can't come back in and take the trust money. Now, in Pennsylvania, there is a public policy that money has to be available for child support, which makes a lot of sense. So we think about a trust, it's a written set of instructions that has all of these players in it. We're going to talk about them, in more detail. So let's talk about this whole thing of, is it a revocable trust or irrevocable? And people can say revocable or irrevocable. One of the biggest things I want you to know is that we act like and we talk like it's one or the other, and that's not true. It's actually kind of a continuum. So we have revocable trusts that are really, really revocable. They can be freely changed. They can be amended. There's nothing in there that can't be changed. And those types of trusts we often use to avoid probate. We often use them so that we can do something with the money on the first spouse's death. Maybe we want freely to change it, but when one person dies, we want somebody else to be able to use the money for a while, but not consume all of it, or if there's any left, decide where else it goes to. So we use those quite a bit. An irrevocable trust means that some part of it I can't change or amend. And there are irrevocable trusts that you can still have a lot of control over. And then there's irrevocable trusts that you really can't have any control over. And so if you think about it as a continuum, trusts fall somewhere in there. Most trusts aren't 100% irrevocable or revocable. They're usually actually a little bit of a combination. So a question I get a lot is, are trusts just for rich people? I'm not sure even what the word rich means. But what I would say to you is that for me, it doesn't necessarily matter how much money somebody has. I'm more concerned of, will this trust achieve a goal? So one goal that we often do is to avoid probate. I have a case I'm working on right now. We're really trying to avoid probate in that situation because we know we're going to have a beneficiary who is going to contest what's happening. We know that the person that I'm working with is making a decision that it's not going to go equally to all their kids. And we know that one kid's going to be upset about it. That's a great reason to use a trust, because when I avoid probate, although that trust can be a question, it's harder to hold things up. We also might use a trust to manage assets after death. So if somebody dies and we want to continue to manage those assets, maybe because that person can't manage the assets themselves. So again, if we have a child who has a drug or alcohol problem, that's a great way to do that. Creditor protection for beneficiaries, maybe they have some creditor problem. Tax planning. We use trust to avoid, protect assets for the cost of long-term care. Or if we have a child who has a disability, let's say one of your beneficiaries has a disability and they're receiving benefits, we want to use a special needs trust so that they can access that money and use that money while still receiving those benefits. And that makes a lot of sense for most people. The one that's not on here, we talk about it a little bit later, but one of the reasons that I use a trust in my own situation is if I died tomorrow, my husband and I both died, all of my assets would go to my 3 children. Well, my kids are great kids. I don't have any concerns about them making good decisions. And they're all, they range in age from like 27 down to 20. So they've started their lives. We kind of know how they're shaking out. But none of them have gotten married or, so I don't know who those in-laws are. So in my situation, if I died and my daughter Courtney inherited, I'll just pick on her because she's the oldest. What if she got married and then divorced? I wouldn't want half of what I worked hard for to give my daughter to go to that other person. This is a real issue, unfortunately, because 60% of marriages end in divorce. So statistically, with 3 kids, I'm going to have a child who ends up going through a divorce, maybe 2. So that's something in that situation. My children receiving it in the trust, although they could be their own trustees, could help in that situation. So why should we consider this for asset protection? We do use an irrevocable trust if we want to protect assets while still retaining control, protecting them from creditors. Divorcing spouses are creditors, nursing homes are creditors. And so often if we actually want some of that protection, it's going to be some form of an irrevocable trust. So one of the things that we want to think about is trust-owned assets that are in a type of trust that we call a protector trust can be protected from the cost of long-term care, an estate recovery lien from the state, or a beneficiary's death, divorce, disability, those types of things, which is really, really important for people to understand, because I often get the question, can't I just give my house to my kids for $1? Can't I just, in fact, I was just at an appointment today and they said, well, can't we just give it to this person to hold? And often people start telling me, well, they have good kids, right? Like I can give it to my daughter to hold for my son, or they can hold it for me. And if I need it, they can give it back to me because I have good kids. Well, no doubt. I feel like I have good kids too, but I understand that life can happen to them. So if I gave money to my children, let's say, again, I'll pick on Courtney. She's the oldest, so I'll pick on her all day today. I give it to her to hold. What if she gets divorced? It's going to be subject to her divorce settlement. If it's in a trust, it's not. But if it's in her name, it's going to be. What if she goes in debt? Maybe she, tries something in the business world and it doesn't work out. What if she herself becomes disabled? What if she gets in a car accident and she becomes disabled? What if she passes away before me? So for all those reasons, we don't want to give our assets to our children to hold because it's subject to their lives, the good, bad, the ugly, the intentional, the unintentional. It's better to take your assets and put them into a trust while you can still be a decision maker. Ultimately, it goes down to those children, but it's not affected their lives, and what happens in their lives doesn't affect it. And I know some of what I'm talking about doesn't happen that often, but my job kind of skews how I think about things. And the reason is because I spend my days sitting across from people that what happened to them is what they never thought would happen to them. So I spend my days sitting with people whose children did pass away, whose children are getting divorced. Often people establish a plan with me, and then life takes a turn and they come back to see me. And it's always great to be able to say to them, you know, I have a situation going on right now where there's a farm, and that farm is in that trust, and they're worried. And I say, don't worry. It's protected against that divorce. We're going to be okay in this situation. Thankfully, you didn't put it in your son and daughter-in-law's name. And so we want to really think about that. And I get that sometimes people want to do that because they think it's simpler. It's simpler until something happens. And then it's really, really messy. And I know many times people say, oh, well, we've always gotten along with our daughter-in-law. Again, on my side of the table, if for some reason somebody was unfaithful and people are ticked off, they typically lose their like little reasonableness. Not 100% of the time, but we do worry about that. And so we want to think about that. And that's why it's really important to know the ins and outs of trust and to really understand how they can work for people and how they can give protection while still allowing people to have control. And so it's more of what we're going to talk about today, you know, moving forward for you. So first we want to think about the donor of the trust. The donor is the person that donates it, gives it. We could call it the grantor. They're granting what they had. So if I had a piece of real estate and I made a trust and I put that piece of real estate in it, I'm the donor of that. And the donor is going to decide what the terms of the trust are and what to transfer to the trust. Now, the terms of the trust, sometimes the law tells us what it has to say. So when I use a special needs planning trust for a child with a disability, there's a law, a federal law and a state law that says it kind of has to say this. As an example, the child who has a disability cannot be the trustee of a special needs trust. The law tells me that. So that's the term of the trust, but I have to follow the law. Most things, though, the donor can tell me. They want everything to go equally to their 3 kids. They want them to get it outright. If there's a second marriage, do we want our spouse to be able to use the money and get income off of it? And upon that spouse's death, it goes to our kids. All those terms of the trust, typically the donor is going to be telling me what they want, and that's how we'll draft it. As far as what to transfer in the trust, that's often something we really help with at our office. So at our office, when people make an appointment, we either have them have a phone call where we gather a bunch of information, or now we have an online form that people fill out. We're going to ask a lot about all of their assets. And some people are like, I don't want to tell you all of that. It's really hard for me to tell you what to transfer into your trust until I have a total picture of your entire estate. So that's something that what I would work on together with you to say, based on what I see here, here's my recommendation. And we write it down here. We put a written back recommendation that says, I recommend that you do this, that you put your house, your life insurance, don't put your IRA or your annuity. So here's what I recommend. And then our office actually helps people do that. But the donor is the person that makes the trust. The trustee is responsible for managing the assets owned by the trust, and it can be the donor. And many times it is. So again, let's say I was working with a couple And they were in their early 70s, and we were doing a trust to protect against the cost of long-term care. We did a trust. We decided they were going to put their house into that trust. They can be the trustee. That means they can still sell their house if they want to. Now, if I was doing a revocable trust, maybe I'm not worried about long-term care. Maybe I'm more worried about what happens at death. Again, often the donor is going to be the trustee of that. Now, typically, there's going to be an alternate successive trustee. So, like for my husband and I, would be our own trustees, and then we would appoint one or all of our kids as an alternate. The law doesn't say how many or how little. Now, I have 3 kids, so I could appoint all 3. I would not suggest if you have 8 kids that you appoint all 8. But you know, that's a personal choice. And part of what we do is talk about the pros and cons and the good and bad with all of that. What's the trustee's role? Well, they have to manage the property owned by the trust. So that could include, you know, paying expenses, maintaining it. If it's a piece of real estate, somebody has to make sure the heat's on, right? This time of year. You could set up a trust checking account to pay for property expenses and maintenance. That person also, if there was, let's say, let's say there was like an investment account in it, that trustee is also going to make the investment decisions. Do we put this in a CD? Do we move it to stock? How is it done? So again, for most people, if they do a trust and we move their assets into the trust, they can be their own trustee. So if they're investment advisor, they're still the person that's talking to their investment advisor. Now, there are situations where when we do this type of trust, a bank could be, or a trust department could be, and a financial institution could be a trustee. That's typically in a case where we don't have family members who are good decision makers, or we don't want to bother them. There's lots of reasons. So it can include that, but doesn't have to include that. Now, as far as a trust protector's role, their job, and I know I'm just mixing around the words, is to take action to protect the trust. They can pull income and principal from the trust and pay the trust beneficiaries during the donor's life. Typically, this cannot be the donor. So again, if my husband and I did this, we were putting our house into a trust, we could be the trustees, we could decide to sell our property, not sell it. But as far as taking money out, that couldn't be us, or else it would be available for care. So again, depending on what type of trust we have, but typically when we have a trust protector, we're trying to protect against something. We can gift assets to beneficiaries. We can be removed by the donor. Let's say the trust protector doesn't do what we want. We can remove that, and we can appoint new trust protectors.
Hey, Julie, a question in the chat. Can there be more than one trust bank account? I have a local trust account and I'm researching an online trust account.
Yes, absolutely. There can be more than one. There's no problem with that. In fact, often people have more than one. So often people might have an investment account at an investment brokerage and maybe some different bank accounts at local banks. All right, so we're going to talk about, well, when does the trust pay out? And it could pay out at different times. Many times they're going to terminate at the death of the donor. So, you know, again, my husband Donald and I, we do a trust and we say the beneficiaries of this trust are our 3 kids. And on the death of the second of us, it would pay out to them. It also could continue after death. And that would be in a situation where, let's say, a third of it goes to each of the kids, but it's going to stay in trust to give them protection. And that's based on distribution plans. So we have situations, again, a special needs trust for a child who has a disability. Typically, it's not going to pay out. It's going to hold it in there and give that money to that child who has a special need as they need it. So really important. We also use that a lot in second marriages where we want somebody to be a spouse to be able to benefit from the money, but not ultimately say where it goes.
Question in the chat, Julie. Can you just put a house in a trust without the money to pay taxes in the same trust?
Yes. You can. So typically that happens a lot. So typically when somebody puts their house in a trust, they're still living there. So you personally can pay those taxes. I have other people who put the house in the trust and they'll put money in the trust and then they can use that money to pay taxes. But you can do that either way, particularly again, if you're living in that piece of real estate.
And the donor can just pay for those costs from the resources that are not in the trust? And okay.
And that's what we're worried about. So what we worry about there is, are we making another transfer to the trust and starting the 5-year look back again? But if you think about it, if you're living in the house, you're benefiting from it. So think about having a life estate or even renting someplace. You're not paying rent, but you certainly can pay expenses for having lived there. Gets a little bit trickier if the house that we're talking about is rental property. But again, usually what's happening there is I'm getting rental income that I'm using to pay those expenses. So who decides what goes into a trust? The donor makes those decisions. Now, again, at our office, we're definitely going to be looking at people's assets and making recommendations. And some of those recommendations can be, well, how much do we want to protect? Some of those recommendations are based on tax law. Like, I'm never going to recommend you to put your IRA into a trust during life because you would have to pay all the tax at once in a traditional IRA. So we look at annuities are another thing that we have to look at an individual annuity to decide, can it go into the trust without an adverse tax consequence? It is important to know that a trust doesn't own property until the donor transfers ownership of assets into the trust. And again, today I had a phone call with another attorney, and I was explaining to that attorney that although this person has a good will and a good trust, they never put anything in it. So they never like retitled the deed or retitled the bank account. And so they're not in the trust until you change the ownership. So like at our office, after we do a trust, we'll end up changing the deed. And like if I was doing this with my own home, my real estate right now says it's owned by Julie and Donald. If I moved it into the trust, it would be Julie and Donald as trustee of the Julie and Donald Trust. But that's important to do, to be able to do that trust. I mean, that deed to move it. Or if I had a bank account, I would open it into a new bank account in the name of the trust. And in our office, we help people do all of that. You know, some offices just do the trust and they give you a written set of instructions on how to fund your trust. I always felt like that's like me going over to Bastions across the street and like buying brakes and them handing me the brakes and being like, here, install it. Here's the instructions. So, you know, I think it's really important that we make sure that your plan's going to work. And so we take the time to make sure that it's funded. So what can I transfer to a trust? I've already kind of alluded to this: real estate, life insurance, bank accounts, investment accounts, stocks, bonds. When we get into annuities, it's a maybe. And sometimes we can, but there could be an annuity contract that has some issues on it. And so it doesn't make the most sense to do that. And so we always want to be able to look at that. What can't I? Retirement accounts. And the word can't is probably a little strong here. You can, but you're gonna have to pay a tax to do that. And so typically we're not gonna recommend that. Also vehicles. Vehicles are really hard to put in a trust. I have done it, particularly like a fifth wheel or a vehicle that's like more like a trailer that you live in. So it's possible, but not something we do often, not something that is, you know, really the best for us to be doing. Now, interestingly, that's okay. Pennsylvania law is really interesting in the fact that if husband and wife pass away, and let's say husband has a bank account of $1,000 just in his name, I have to probate and work really hard to get that $1,000 to the spouse, unless it's either in the trust or jointly owned. But a vehicle, so it's funny, $1,000 bank account. But if somebody has a Cadillac, you know, it's worth, you know, $50,000, I actually can move that easier. So the fact that it's hard to put in a trust is okay because the law allows me, even at death, to move that easier other ways. Doesn't make a lot of common sense to me, but it works. So what are the advantages of sending assets to a trust? Well, if it's a type of trust that protects against long-term care, then we're going to be able to be protected from that. And that means that it doesn't mean that we won't be paying any money for our own care. It means that we could use whatever benefits are out there. So sometimes we get some in-home care and people are still paying for more in-home care. We are protected from our lien. So sometimes the state helps pay for care, but then they come back and they take the real estate from the beneficiaries. And as I talked about before, it protects against a beneficiary's death, divorce, disability, or their own debt.
Julie, what's the difference between a will and a trust?
Oh, good question. So a will, last will and testament says, here's where I want things to go to. And when somebody dies, we have to appoint whoever is the executor. So we get a copy of the death certificate, we do a petition, and then we go to the local county court and we appoint somebody as the executor. And that process is called probate. And once I probate something, then I have to follow the probate rules. I have to give notices, pay inheritance tax. And if I have any creditors, they can come against that probate estate. So a will says what happens to my stuff at death, but it gets me into a system that can take some time and energy. A trust has some advantages in the fact that it might still say, here's what should happen to things when I die, but it avoids probate. And so that avoids some of those fees. It also can avoid some creditors that can only come against my probate estate. And that's really important. Now, there's still a system in Pennsylvania that you have to follow, but it's a little bit less. So I like to use revocable living trusts in situations where we want to avoid probate for whatever reason. So it's really important if you have any real estate in any other state, particularly Florida, that you take that real estate and put it into a trust to avoid probate in that state. Because particularly Florida is actually much worse than Pennsylvania from my perspective in the probate. The disadvantages of transferring assets to a trust, the trust might say that for whatever reason, the donor can't withdraw those assets. That only the trust protector can. So like in my situation with my husband and I, that would only be our kids that can. But remember, in most of those situations, if they don't do what we want, we could fire them. But we do need to know that it is a written set of instructions that we have to think about because we need to follow them later on. So what about taxes? So this is a huge question that I get where people may say, oh, you shouldn't do a trust because you're going to pay more tax. That's not necessarily true. Most of the trusts that we do at our office are what are called grantor trusts. And that means for IRS purposes, the grantor or the donor, the person who made the trust, retains so much control over the trust that the IRS says, we don't even think it exists. So they're using the donor's social security number. We wouldn't have to get an EIN number. All the trust income would be reported on the donor's personal tax return just as if they owned it themselves. It's taxed at the donor's tax bracket, again, just as if they owned it themselves. It is still subject to Pennsylvania inheritance tax, but beneficiaries receive a step-up in basis. They don't have to pay capital gains. So and we'll have an example of that a little bit later as far as like a house. But just so you know, many times I actually want to pay Pennsylvania inheritance tax, particularly on real estate, so that later on I'm not paying a capital gains tax if I sell it. So sometimes avoiding inheritance tax leaves you with a larger tax, a capital gain. But most of our trusts for IRS purposes are considered grantor trusts, and we just use the person's social security number. Another type of trust, a non-grantor trust, means the grantor doesn't have control. And then we have to go apply for an EIN number, which is like a social security number for trusts, businesses. They are taxed at a higher rate. And many times in that type of trust, if the donor survives for more than 1 year, it's not subject to Pennsylvania inheritance tax, but it's still subject to capital gain. Now, if I had a situation where maybe I had a CD in there, I might want to avoid the inheritance tax because I'm not going to be paying any capital gains. So this, whether or not you use, which of these you use can depend also on what we have in it, in the trust that we want to be looking for. But for Pennsylvania inheritance tax, there is tax in Pennsylvania. Pennsylvania is one of only 11 states that has an inheritance tax, and we do tax $1. For spouses or children under the age of 21, it's a 0% rate. For direct descendants, so that is children, stepchildren, grandchildren, step-grandchildren, it's 4.5%. Sibling is 12%. And 15% for all other heirs. What are other heirs? Nieces and nephews. They're treated the same as like a mailman. It's a 15% rate, and so we often want to think about that. Or if two people live together and they're not married, there will be that 15% inheritance taxes. So I can't tell you how many times I've been in a situation where two people live together and one person is going to pass away. Maybe they have a diagnosis and we kind of know that, and we have this 15% inheritance tax. And we have to think about, do we get married to avoid that tax? So that's something I take very seriously because, marriage has implications for people's values and their own religion. But certainly from a tax standpoint, sometimes it makes sense. There's also a Pennsylvania realty transfer tax, which is 2%. We always pay that when we transfer real estate, unless there's a person that's an exempt, like children, grandchildren. The problem with Pennsylvania realty transfer tax is it doesn't exempt step grandchildren like Pennsylvania inheritance tax does. So these two things deal with things differently. All right, I see we have some questions. I'll kind of stop for them.
I think you may have covered this, but just to refresh, what if you and your husband get a divorce? How's the trust handled then?
Yeah, so hard. So let's say my husband and I, Donald and I, do a trust together and we get divorced. That trust is not going to help or hinder what would be equitable distribution. The courts are going to look at how long we've been married, who makes different money, and they're going to do equitable distribution. If it goes to my daughter Courtney and she gets divorced, it's going to protect that from that divorce.
If you have a will, does it still go to probate?
It does. Yep, it does. Yep.
Does common law wife exist?
No, that's an interesting question. In Pennsylvania, common law marriage does not exist anymore. So when I started my career in the 1990s, it did. And I forget exactly when, but it's been, I would bet, 20 years since we've had common law marriage in Pennsylvania. So it used to be after you lived with somebody for 7 years and you held yourself out as husband and wife, that you became common law married. That does not happen anymore in Pennsylvania. You can live together for 30 years. You can call each other husband and wife, but unless you actually got married, we are not going to be considered married. So that's important to know because some people still think that exists and they think that when they pass away, their person's going to be treated as a spouse. And that's not, I've actually done cases where that was when common law marriage existed, actually was court appointed for cases where that was the question. Were these people common law married? Should the money go to the kids or to the spouse, purported spouse? And they were hard cases. So I think it's good that common law marriage was abolished in Pennsylvania because I think people should either decide yes or no. And then that way we know, because otherwise we were just guessing. We're interviewing friends, family, and just kind of guessing.
So if you set up a trust, should you drop your will?
No. And that's a great question. You guys, you're asking really good questions. Now, And the reason is you're not going to use your will very much, but everybody always has a little bit that goes to their will, like their car. And so you shouldn't drop it, but please know it'll cost less to probate because there's going to be less that goes through it. And if anybody starts arguing, they're not going to be able to hold it up. But you should still have a will. Now, a lot of times we'll do a will that just pours over into the revocable living trust. So we say the will is very simple. It just says everything I have goes to my trust, and then they deal with it that way.
We are all caught up there with the question.
Right. Thanks. Yeah, so the other taxes that we worry about are federal transfer taxes. So in Pennsylvania, they tax $1. But for federally, you have to have $13,610 in 2024 to worry about federal estate taxes. Now, we have clients who worry about federal estate taxes because they have more money than that. And that's definitely a situation where we use a trust. I will tell people, though, that $13 million is going to sunset. That means that law, unless the legislature, the federal Congress takes action, that will go away, and it will sunset back down to somewhere, it's inflation index, so we don't know exactly how much, but somewhere around $7 million. And so that's a huge difference between 13 and 7. So the end of 2024, that's going to happen. So if you're anywhere in there, it's really important that you look at your planning this year and make some decisions based on what you want to have. Reason that's so important is the federal taxes are 45%, not 4.5%, 45%. So a lot of money. And so, if you have, years ago, the exclusion used to be like 625,000. Now, please know people can get to this quicker than they think because it does include the real value of all your real estate, includes life insurance, business interest. So more people could get closer to like the 7 or 8 than what people would think.
So Julie, it sounds like it only makes sense to have an irrevocable trust in order to protect assets from long-term care expenses. A revocable trust would not help with that.
That's correct. Yeah. Federal gift tax it used to be that you give away $10,000 a year to every person. Now it's 18. And so, but again, if you don't have a huge amount of money, you don't have to worry about that so much. So often we have people who give away more than 18,000 and they're okay with it. As long as right now the law would be, if I give away more than 18,000 in any 1 year, as long as I don't give away more than 13 million total, I'm okay. And I know a lot of you are probably listening to me like, oh, I'm not even close to 13 million, so it doesn't matter to me. Then you're in a situation that you don't worry so much about the gift tax. You're worrying more about the nursing home care. Income taxes, there are different thresholds for individuals and non-grantor trusts. That's why a lot of times we use a grantor trust so that it's no different. And of course, we'd have to pay state income taxes, which really it doesn't matter. In Pennsylvania, it doesn't matter if it's in a trust or not. The rate's the same, no matter what. So just talking about, we already talked about this a little, like a will versus a trust. In both, we might be paying inheritance tax, although there are trusts where we wouldn't be paying inheritance tax. It's going to depend on what the terms of that trust says. For a will, there is a probate fee. For a trust, there isn't. So, and the probate fees have went up. I don't want to overstate what they are, but they have went up in recent years, at least, from what I see. They can be slightly different county by county. Attorney's fees. So typically, attorneys, the law in Pennsylvania is that attorneys could charge more for a probate estate than for a non-probate. Now, I have to say to you that at our office, we don't follow that anyways, because honestly, for most of our clients who come to us and they set up a really good plan, part of that is to save these taxes and get these protections. But part of it is also to make it so that when people die, their spouse or their children don't have to do as much. And if they don't have to do as much, we don't have to do as much. So to our office, the fees might be less or more equal. They might be less both ways, simply because you already did some of the work ahead of time. You made sure your beneficiaries are up to date. You made sure it paid out the way that you wanted. So that helps. It's like sometimes people are doing some of the work now, so their children don't have to. Attorney's fees are going to be kind of the same again for a wills and a trust in our situation. The executor's fees and trustee fees, again, pretty similar. It just depends on what the people have to do. As far as the beneficiaries contesting, it is easier to contest and hold up a will than it is to contest and hold up a trust. And so I think that's a really important consideration. So sometimes I'm using a trust simply because I know I have a beneficiary that's going to be upset. And we don't want them to be able to hold up things, particularly if we have a business or something like that. So trusts do avoid probate. We do avoid the probate fee, but I don't want people to be overstating it, because I don't want people to think there aren't things you don't have to do. Like, you still have to pay the inheritance tax. We still are going to do notices. There's still the advertisements that we have to do in the newspaper. We're still going to do some tax returns. And so it's kind of the same process, less expensive because we don't have the fees, but it's not that it's nothing. So sometimes I hear people say I don't have to do anything. That's not really true. The law still says in 2016, Pennsylvania adopted the Uniform Trust Act, and it made it similar. So less expensive because we don't have a probate fee that we pay to the court. We don't have the court oversight, but we still have some of the same steps. So I always want to be really fair about that to people. Well, my trust, let's say I do a trust for the cost of long-term care. Will it limit my options or level of care that you receive? It really does depend. So I can use an example of my father-in-law. He had dementia for 14 years. And in his situation, we had made it so if he had went into a nursing home, he could have gotten the state to help pay. And that's important because my mother-in-law, still living today, she'll probably outlive all of us. She's like 86 years old and still works. But in his situation, we ended up putting him in a place that was a dementia care unit. We thought the care there was better, and my mother-in-law made the decision to pay for that care out of her pocket. And I think that was the right decision in that situation. Now, she had cared for him, so we were really at the end of his life. And so we knew that we wouldn't be paying all that many months. But I want people to know that when we talk about using trust to protect against the cost of long-term care, one, we have to understand that there's only certain levels of care, nursing home care, in-home care, that's paid for, but like things like assisted living, personal care homes are not. And so there's different levels. Now I have to say, we are really lucky in North Central Pennsylvania. We have really good care here. I know it's not perfect, but just because somebody's on Medicaid does not mean that they're not getting good care. Please know there's areas of this country that is true. But here, the staff, I don't think they really care. And I think that while it's not perfect, I think the care in some places is quite good. I also would like to say to people that the care that you receive, it's really important that we think about the diagnosis that somebody has. So sometimes where you should get your care really does depend on your diagnosis. So like my mom just had a real issue. She was very sick and she really needed rehab. And so I wanted her to go to the best rehab facility. Now Medicare paid for that, but I think that that's important for us to understand. So what about Medicaid? Let's talk about Medicare, which is the insurance that we get through the Social Security Administration. But for Medicaid, which is what really helps pay for in-home care, nursing home care, the life program, there is a look-back period. So whatever you give away in the last 5 years affects that. And I think that's important for people to know. It's why people should do trusts while they're still younger and not sick. Sometimes people wait until the crisis occurs, and please know we can still do some things, but not as much. So if you gift assets to individuals or a trust within 5 years, Medicaid's going to deny the application. They're going to say you gave away assets, and they're going to impose a penalty period. So I'm going to talk a little bit about that. Basically, they penalize you 1 month for every $11,547 that you give away. And that's because that's the average cost of long-term care in our state. Interestingly, it's went down the 2 years. First time in my career, it's went down. Usually it goes up and up and up. It started out at about $1,800 a month in like 1994 when I started this. So it's really in 30 years has, 5 times over increased. So what does the penalty mean? Medicaid's not going to pay for our care. So let's say you gifted property, real estate, that's worth $200,000 to a trust. We take the $200,000 and divide it by the $11,000 and we come out with 17.3 months. So they're going to say, have you given anything away in the last 5 years? We say, yes, we did. They're not penalizing us 5 years. They're saying, well, our penalty is 17.3 months. You gave away $200,000. We divided that by 11,000, what that would pay for. And so the penalty is 17.3 months. So example, you transferred $200,000 in November of 2018, and you go into a nursing home November of 2022. So 4 years later. The 5-year look back doesn't expire until November of 2023. So you only have 12 more months to look back. In that situation, if you had given away the $200,000, we'd recommend that you self-pay for 12 months and then apply for Medicaid. So what happens there is in that trust or what you gave away the $200,000, about $138,000 would be used to pay for care, but the other $61,000 would still be protected. And honestly, what happens is a little bit more is protected because everybody has some income. But we don't want to make this example too complex and kind of lose you in it. So what I want you to get out of that is that all the time we have people who don't make it through the 5 years. But in this situation, they protected $61,000 that they wouldn't have otherwise protected if they didn't have the trust. So let's say Harry Smith has a house valued at $200,000 and he has $400,000 in assets. In 2012, he puts his name and $300,000 in the protector trust. He's admitted to a nursing home in 2018. He spent $100,000 on personal expenses. In that situation, he made it more than the 5 years. And so he protected his $200,000 home, his $300,000 in asset. They're not available to pay for his care. Really important in a situation where maybe Harry has a spouse. Really important in a situation where maybe some of those assets are a business that somebody else in the family is currently employed in or would like to take over. What happens if he doesn't set up a trust? Let's say a person has $200,000 and $400,000 in a house and $400,000 in assets, no planning, didn't do anything. They go into a nursing home. What the law says is that they're going to be able to retain about $8,000, depending on their income. So they're going to pay the nursing home bill until all of that's consumed. Now, please know if you came to our office, we'd still be able to do some planning really at the last minute, but it's not going to be as good as the outcome of the person who planned ahead. So when should we consider setting up a trust? I think a lot of times, when people have an empty nest, children are grown and out of the house, we now know we don't have those expenses for, raising those children, educating them. If we have any accumulated assets that are readily available that could help pay for care. We have a family history of medical conditions. I have a lot of people who come to me who say, my parents had dementia, and I know that Alzheimer's, for instance, is hereditary. So I'm worried that this is going to happen to me. You want to protect your real estate and assets. Now, please know, some people could come see me, and based on your individual circumstances, I could recommend to you to buy long-term care insurance. Now, I don't necessarily like the traditional long-term care insurance, which is the type of insurance that you get that's like your house or your car. You kind of pay it as you go, and if you never use it, you lose it. There are a lot of really good companies out there that have long-term care insurance where you're moving part of your money, and if you never use it, there's a death benefit. So you don't have to risk never needing that type of care. So, for everybody individually, I'm trying to give as much information as I can. But for everybody individually, if you've already been to our office and you have questions, you should come in and review your situation and what you did and how is that different now that you're older, or maybe the law has changed. And if you've never done that, I really suggest that have go over what you have, what does that mean, and what makes the most sense. At our office, we really like to get involved, not just with these assets, but to make sure that you're going to get good care. And so we've added elder care navigation where if you are having a healthcare crisis, something going on, particularly we see a lot of people who are dealing with dementia. We don't want you to wait until the very last when like everybody's exhausted and it's just not working out. We'd want you to think about what we can do to make a comprehensive plan to make sure you get good care and maybe get some care in the home and not wait for the nursing home care. So at our office, we have an attorney on that team, a long-term care planner, certified Medicaid planner, a care navigator, which is the liaison between the family, nursing facility, or whatever facility, paralegal, and a legal assistant that really allows people to find the answers. And I just share this with you because dementia is a huge issue to me. And I think we have this kind of dementia care journey, which is, kind of a little bit more of a chutes and ladders, if you will. So if you have any questions about dementia or dementia care, that's definitely a situation where we would be using some trust to help protect assets and making sure that somebody was able to get the best care possible.
And Julie, we had a couple questions come through the chat there. Can grantor trusts be either revocable or irrevocable?
Yeah, I love that. So there's all revocable trusts are grantor trusts. Some irrevocable trusts are also grantor trusts.
And what is the recommended age for elder planning?
So for elder planning,
Or elder care
yeah,
navigation? Yeah.
that is really hard. Because if you could tell me when you're going to get sick, I could give you a good age. But I mean, I think for some people, I think when people, again, so people should have basic wills, powers of attorneys at any age. But I think once you become like an empty nester or think about your own retirement planning, I think that's a great time to do it. But I'll be honest, I meet with people every day that never did this and they're, 75 and, it's a good time to start then. And I think sometimes if you're a little younger, we might start and think about things, but we might not be as aggressive in our funding and later on do that. But I would say, if somebody really push me, I would say up until the age of 50, everybody should have like wills, powers of attorneys, and maybe need more than that. But once you hit 50, and I hate saying this out loud, like I turned 50 this year and I'm putting myself into that category. I think then you really need to seriously consider this. Yeah. So
You're
yeah,
over the hill now. You've
I
reached
am. Yes. So I've been talking a lot about this. I'll just tell everybody a little story. I recently went went skiing at Lake Tahoe, and I have a son who really loves to snowboard. So I had skied like 30 years ago, and I thought maybe I can do this. But as I got there, I was like, oh my goodness, like, am I gonna kill myself? Am I gonna like, what if I break a leg? How am I gonna get home on the airplane? So it was like this big deal. But I want to tell everybody, I did ski. Now I've skied the Big Easy. It wasn't like on a black diamond or anything. But I did do that. But one of the things that really irritated me was I was taking a lesson and my ski, like I'm skiing and my ski came off. And I was like, why did my ski just like fall off? So then my instructor says to me, and she was young, she says to me, well, you're over 50. So they'll make it just come off real quick in case you're gonna fall. And I was mad about that. And she said, well, you should get it changed because if it's coming off, it's actually more of a problem to you. So I went back and the woman made me like lie and say I was still 49. But if you're 49, they set your skis one way. And if you're 50, they set them another way. And I was irritated. Any
A
other question?
safety, like a safety feature, huh?
Yep, it is.
Yeah, what happens when there is joint ownership, like in for your house, joint ownership?
Yeah, so joint ownership between husband and wife is great. Unfortunately, joint ownership doesn't protect from the cost of long-term care. So it used to. And we have this more less of a, the house that people live in, more in like people had like cabins or properties that maybe they owned with like a brother or sister. It used to be that that was protected from medical assistance from the nursing home, and now it's not. And so if you have joint ownership, that's something you should really look into, particularly if it's like one of those cabins that really has more sentimental value. We would want to put that into a trust. Um, I do have some direct messages here that I will just answer so you know who you are. Um, was a question of like with the common law marriage, are you grandfathered in? You are not grandfathered in under law. It's like you were common law married and now you're not. And please know, I answered that question more for an estate planning point of view. There are other parts of the law like workers' comp. There's other parts of the law that might answer that differently, moving forward. Um, Somebody's asking if you're a power of attorney for your mother's estate, can you set up a trust for her home and assets? Absolutely, you can, as long as the power of attorney gives you the power to do that. So not all powers of attorneys are created equal. That's one of the things we would first look at to make sure you had two powers. One power is the power to create trust, and you can actually just open the document and see that. And the other is I need gifting powers, and I need it to say unlimited gifting. If it says limited gifting, I can't do it. Really important from that perspective. There is also a question on here of about like if you get a group of people together, would we speak with them? Absolutely. I think the more that people can know about what it is they're doing or what their options are and plan ahead. And that's something you could always email Kyle about, and he could help facilitate that. Finally, there's a question. Can you explain the principal and income in an irrevocable grant or trust thing? That's a really complex topic. But principal is typically like what you started with. So let's say we had a CD and it was $100,000. When I put that in, that $100,000 is the principal of it. The income could be, let's say it makes $5,000 a year. That would be the income for it. Now, stuff like that, so I picked a pretty easy example. When we get into things like gas rights, it's not as easy. The trust itself can say what's principal and income. If it doesn't say it, gas royalties are deemed a third of its income and 2/3 of its principal. That's because if you think about it, gas wells, they end up having a lifespan, if you will. They end up being consumed. There's like a bell curve. Like first you get a whole bunch of royalties and then you don't. Timber's another thing like that. The question is, if I timber and I get money for the timber, is that principal or income? Other things though, like if I had a property in there and I got rental income, the property is the principal, the rental income. Now things can be income, and if they're not taken out of the trust, they become principal. So if I go back to that easy thing of the $100,000 CD and it made $5,000 and that was the income, if I don't take that out, it might be because that becomes principal in the trust. So important. The trust also could have its own definition of principal and income. Otherwise, what I was talking about was kind of the default rules, which the default in Pennsylvania is what the IRS would deem it to be. So typically I can't see the questions. I had opened that up, and I'm going to go back to my PowerPoint now. So positives of pre-planning. Even if somebody doesn't do planning in advance of a crisis, there's still always ways that we can protect it. But you are better because there's more flexibility and control. And I would say to you, the other thing is that for me, I'd rather work with the person that we're doing the planning for, because then I know what that person wants. Or at the very least, like there's a power of attorney, like I know who they wanted to speak for them. It's always really hard when I get into situations where the person can no longer tell me who they want to speak for them. And so, it's really important. At our office, we have a team of attorneys, certified Medicaid planners, care navigators, and support staff who really can help you through the whole second half of life. The neat thing is that we do the planning, but then we can also help when that crisis hits. We do pride ourselves on individualized planning. We want to know your situation and what works for you. Quality documents. And our goal is to really give you peace of mind. So this is, just a client that used us that talked about being so glad because a friend of a friend told them to come to us. And in this situation, her mom was going into a nursing home and she needed a way to pay for it. And in that situation, we did a plan that included a trust. And the annuity from the trust with their Social Security paid for care, and they were able to protect some assets. So in your situation, what we suggest to people is to do a long-term care strategy session. Now, if you're on here and you think long-term care is not your issue, it would still be a strategy session where we'd be talking about maybe more in your situation, taxation issues that you have to think about. But what happens is you can do that via email, via Zoom like this, via phone, or in person. And during this meeting, we'll look at your old estate planning documents. You have them and ensure they're in good order. And I always, sometimes I look at them and I think they're done well and they don't need to be updated. And sometimes I look at them and they seem to be done more by a general practitioner. And I do think they need to be updated. We develop a plan for your second half of life. And of course, we answer all your questions about your unique situation. So at the end of that meeting together, you'll know what documents you need, you know what your options are. And our hope for you is that you have peace of mind knowing that you're going to be ready and that your family will be ready and you won't be a burden. After our meeting, we develop a written plan with recommendations. And I think that's a really important thing that I pride myself on at our office. We have a written plan. And we always continue to update that. We'll share that with your financial advisor, your accountant, your children, anybody you want us to. And then we work together to implement that plan. We do the legal documents, but I think most importantly, we walk you through it from start to finish, which means that if there is any type of funding that needs to be done, we help you do that. We do offer a free strategy session for having come on here. We figure if you listen to me for an hour and a half, you know a lot more than what you used to, and you're helpful to that. So what's the catch? I mean, I was already asked, what age? That's always hard. The catch is, it's your health that's important here. So we want to do that before somebody's sick. The other catch is sometimes, people wait a little bit to get in with us, but I can assure you that once I start with you, I get it done. So I manage how many people come to see us at any point in time. And Kyle, I see that there might be more questions.
The question in there, dealing with pricing, can you guesstimate the cost to do this type of work, Julie?
Yeah, I can estimate. So when we talk about some of the documents, we talk about like powers of attorneys, wills, those things are in the hundreds of dollars. When we think about, doing a wills, powers of attorneys, and depending on your situation, if it's a simpler situation, we have an online form that you can fill out and save some money. But when we get into trust, we can get into thousands of dollars. And it's going to depend on your unique situation. But you will get into more money there because we're doing a trust. We're also funding it. That's something that at the end of the hour together, we would tell you exactly what it is that you would be looking at as far as an investment to help protect that. So to do that strategy session, just click chat with sgy.com. So you can just open a browser and type that in, and it will take you to a calendar. Or you can email at info@PA Elder Council. Or you can call her off, whatever feels most comfortable for you. The idea is that we want you to have an estate and long-term care that's updated to current law. We want you to know what your payment options are for long-term care and how to protect your assets in case a crisis occurs. And we want you to have peace of mind. And for many people, after we do their planning, we really suggest that if they have children or whoever their beneficiaries are, that we share that plan with them so they understand that there is a power of attorney and what does that mean. We're here for you. So, stay connected, like us on Facebook. You can subscribe to our YouTube channel or listen to our Second Half of Life podcast if you want more information. They're on our website, the podcast. Anybody have any questions?
Do you work with our financial planner? Who?
Yeah. So typically we would want to get your financial advisor involved. So if we made any recommendations, we would want to talk to them. And we can do that. Sometimes they come to our office. Sometimes I talk to them on the phone. Sometimes we send them the written plan and idea, because they might know you better, and know some of your needs of your income and what your financial goals are. And so we love to work with them and partner with them in making sure that this works for everybody.
Does a husband and wife create one trust?
Typically, typically, um, unless they don't like each other. No, I'm just joking. Typically, yeah. But there are times that we don't do it that way, but I would say 95% of the time it's one trust.
Is the 18,000 gift per person?
Yeah, it is per person.
Would a trust be a good tool for people with gas rights?
Yes, 100%. Yeah, we do those often.
And thank everyone for your time, for coming out, listening. Julie, thank you for your presenting here this afternoon, your time.